purpose. That's why I like it. Good afternoon and a very warm welcome to this, I think, 17th edition of Talking Disputes. My name is Hannes Schlömann. I'm with WTI Advisors. And together with our dear friends at ICTSD, we're very happy to welcome you here this afternoon. You, that is everyone in the room, but also everyone out there in cyberspace, unknown, unseen, and yet much appreciated. A special thanks must go at the very outset to Finland, that has kindly agreed to make this possible, that we can be here. As you all know, whatever you say can be used against you in court. In this case, the court of public opinion. Out there, this event is being web streamed, so be careful what you say and what you think. We are also receiving comments online, and that goes either through the event website, that's on the ICTSD website, where you can post comments directly, or via Twitter with the hashtag Talking Disputes, or at ICTSD Trade Law, or at WTI Advisors. You will be read and understood, hopefully. Let me already mention to you before we go into the substance, formalities always have to be observed, and one important one is feedback forms. We need to know from you what you think at the end of this event, so please do take the 2 minutes that it takes to give us your feedback. Today we're discussing a case that is very close to my heart, because it is about services, and I think services will be coming a lot more up in dispute settlement. I believe that's a fair prediction. We have had 21 years of GATS, not half as many cases, and I think that's a ratio that needs to change, because as we all know now, services make up probably north of 50% of world trade if measured properly. We're getting there. Statistics still don't do what we want them to do, but we're getting there. So services are important. I think everyone has taken note. Financial services are among those that elicit most attention when people discuss the difficulties of trade and services. And that's also a point where some governments, legitimately or less so, feel that they should perhaps not engage as much in services because they're afraid of certain effects, specifically in the area of financial services. And of course, as we tweeted a few days ago, in a way this is Panama Papers going WTO. We are at the center of world attention in many ways with this case, and I think that is something of high interest to all of us, and should be if it's not yet. I'm joined today by 4 speakers. 2 are right here with me. 2 are not visible on screen just right now, but they are still there. Let me start in the order of appearance with Daniel Crosby. Daniel Crosby, a partner of King & Spalding. Daniel, with no exaggeration, is the man who introduced me to services in a much, much earlier life. And he has undoubtedly a lot to say about that. He's also particularly interested, and has been for a very long while, in financial services. I think one can say that. Daniel will introduce the case to us and offer a few comments, some of which you might not necessarily expect. We'll see about that. After that, we'll have another lawyer comment, but certainly not just another lawyer. Professor Joost Pauwelin is well known to everyone, doesn't need any introduction. But for those of you who outrageously haven't taken enough note yet, let me just say that he's a professor at the Graduate Institute here in Geneva, has, I think, in many ways made it a world power in international trade law, and he's also a visiting professor of law at Georgetown University. Again, that's no accident whatsoever. Joost, of course, for those of you who have followed the services file a little bit over the past years, has coined one of the more beautiful titles around, which relates directly to today's subject, the unbearable lightness of likeness. And we'll see today whether it is perhaps the heaviness of likeness that is unbearable. But I'll let him comment on that. He will be followed by Jacques Sasseville. Jacques is head of tax treaty unit of the Fiscal Affairs Division at the OECD and has a lot to say about international taxation and tax avoidance, tax evasion, and all those different ways of not paying taxes. And on the related international cooperation, and I'm quite anxiously looking forward to how he will position this case in that bigger picture. John Cook he has been around at least as long as there is talk about trade and services. John Cook is the chairman of the City UK's Liberalisation of Trade in Services Committee. John Cook has been active on services, trade and services, in particular financial services, for a very long while. Many of you must have met him and interacted with him over the past years. I hope I have done reasonable justice in this short introduction. Let me remind you that, as we always do in this house, but particularly now as we web stream this event, please do use your microphones when you speak. That applies to all of us, of course, because otherwise the people out there cannot hear you. So without further ado, let me hand over to Daniel to introduce to us this case. In some ways, one of the shortest appellate body reports ever, because it technically ends on page, I think, 43. And after that, the appellate body just keeps commenting. But I think gasoline was shorter than that, if I remember correctly. But in many ways, the appellate body just wouldn't let go. And I think that's one of the reasons why we're having a little bit more to talk about. But behind every appellate body report is, of course, a panel report. And there are certain things that were not appealed. But I'm not the speaker here today. I'm the moderator. So without further ado, let me hand over to Daniel. You have the floor.
Thank you, Hannes. And Hannes is very humble, so didn't really introduce himself. So let me just give a 10-second. Hannes is one of the leaders in the world of thinking in this area. And I think the best thing that Hannes does is think outside of every box. And if you spend more than 10 minutes with him, especially after one glass of wine, you know that he's very good at exploring things that nobody else thought of before. And these issues that we're talking about today go down some of those lanes of thinking. So thank you to Hannes, World Trade Institute advisors, and ICTSD for bringing us all together. And away we go. So just a bit of context while you look through those measures. It was already mentioned, the Panama Papers. The Panama Papers didn't happen only in one day. The big news came out in one day, but we have a long history and a recent focus on money laundering and tax avoidance and all these issues. Countries coming together in two fora that are very relevant to this case. One, Jacques will talk about, OECD, the Global Forum, where they address transparency and information sharing, and the Financial Action Task Force, FATF, which a long-standing collaboration to try to address these issues that hurt everyone if you don't solve them in a proper way. So then, of course, the Panama Papers come out and show exactly that we were right. There was a problem here. And the one other piece of context that I'll share with you from my perspective before we launch in is the United States. You can tell from its submissions in this case and the reaction to the rulings is very nervous about financial regulation, prudential regulation, and the piece of context is in the TTIP negotiations with the EU, the United States has a kind of longstanding position of excluding financial services, in particular financial services regulation, from the scope of the negotiations generally, although they're obviously covered by the GATS, and we'll talk through that now. But the context is much broader than just this case that illustrates some of the points. In red, measures 5 and 6, you see two measures that are more specific to financial services. The other measures are implemented by Argentina in order to address the issues here, collecting tax, obtaining information to apply the correct tax from their perspective on transactions that are housed or conducted outside of Argentina, especially with countries that don't share information about those transactions and tax bases. So as Hannes said, the case is very, very short. It appears on this slide. Really, there was only one issue that was appealed. So we have the issue of whether or not cooperative countries, services and service suppliers are like the same suppliers of the same services from non-cooperative countries. So this is the defined terms at the top of the panel report. Cooperating country service suppliers and non-cooperating country are presumed to be like by the panel, according to a presumptive test where if the distinction drawn by the measure is based on is exclusively based on origin, then you can presume that those two services and service suppliers are like. And then they went and talked kind of beyond that issue, the likeness factors. In the goods jurisprudence, there are 4 factors: the properties and nature and quality of the product, the end uses of the product, the consumer taste, habits, and perceptions, and tariff classification, which the panel held in this case should be the same as CPC, Central Product Classification for services. There should be a competitive relationship, although the panel noted that there is a greater complexity for 2 reasons that it noted in particular. One, because there are services and services suppliers, and the suppliers are not something that has a comparative point in the GATT. There's no analogy to the service supplier, which are regulated in different ways from goods, and also the role of domestic regulations on the services and service suppliers and consumer preferences. So the panel ruled that they're like, based on the presumptive test, but then went on to say, well, it's not exactly based only on origin, but on a regulatory framework that is inextricably linked to origin. And so when the appellate body looked at that, they said, oh, that point that you added there at the end about regulatory basis inextricably linked to origin was the basis for the reversal, and therefore bringing down the conclusions that anything was like, and therefore that there's a violation of any of the challenged measures under both MFN and national treatment. So the appellate body basically said your test is okay if you really have an exclusively origin-based distinction, but if you go beyond that, you should really analyze the likeness factors. And they didn't to the extent they should have, and so they lost. And there should have been the end of the case. There was the end of the case. And then you see here, and they even say, and therefore rendering everything else moot, paragraph 6.83. That's the end. And then we have the however. Let's make a few additional or extra findings. And they gave a basis for doing this. Worth a look, but maybe Joost will talk that through. Just to give you the kind of layout of the case, the panel also looked at whether treatment no less favorable was accorded under both MFN and national treatment. And the issue there was that the assessment of whether the measure modifies the conditions of competition must consider the regulatory aspects. Again, the regulatory aspects comes in, and there you have the question of whether Argentina has access to this tax information and whether these measures are therefore tied into some regulatory scheme. The appellate body rejected that interpretation, and the analysis as well. It said there should be no consideration of regulatory aspects as a legal framework, and then as you apply that legal framework, you should not have considered the regulatory framework, and therefore your whole system falls down, and there's an error. Then we have the second issue out of three, where additional findings were made, whether the measures, specific measures not including the two financial services measures, were justified under the GATS General Exception, Article 14. The panel found that the measure, that Argentina's measure was not justified because there was an arbitrary and unjustified discrimination in granting and deciding which country was cooperating and which country was not. There were some countries that were similarly situated that didn't get the same treatment, and the panel thought that therefore it was not justified as an exception, similar to other jurisprudence that's come down on the good side. So issues that were not appealed were the chapeau under the GATS Article 14, and the finding that Argentina had not justified the measure, and there were a series of complaints there. But there's a very narrow challenge, not to the chapeau or the finding in the end, but just to one of the entryway pieces. As you know, you start with the subparagraphs and see whether you have a provisional justification under Article 14, C in this case. And if they're necessary, then you get back up to the chapeau, where Panama targeted the necessity analysis, and the appellate body ruled that it was actually necessary to secure compliance. But I'll just note for timing that the analysis, the discussion about the chapeau was not challenged and stands to the extent the panel report has life left in it, which depends who you ask. There are some interesting findings that Article 14C is an illustrative list, so everything doesn't have to be in there. You can argue basically outside of that, and don't have to specify exactly what you're up to. The measure has to be consistent with WTO rules, like in goods, and then there's the necessity part of that, where they go back to EC seals and talk about the importance of the objective, contribution of the measure to the objective, and the extent of trade restrictiveness. The burden was on Panama to identify alternative measures. As usual, the panel said that Panama did not identify alternative measures, and then the appellate body moved on, just to say that one of the issues that Panama targeted was whether the measures issued, the measures that Argentina said justified its measure were tied to the logic of the measure, and secondly, whether or not that that whole framework was necessary in the end. So that's enough of that. So Joost has some. So the third and final ruling, whether measures 5 and 6, the financial services measures, were justified under the GATT's Prudential exception. This is a very interesting tour of this provision. The first time it was litigated, and the panel found that it was not justified because the measures were not taken for prudential reasons. But Panama only challenged the piece of that, or the strongest challenge was on whether it was because it was domestic regulation. Somehow the measures could only be covered by the prudential exception under paragraph 2A of the Annex if they were tied in, somehow related to Article 6 of the GATS, which discusses domestic regulations. And the appellate body, the important ruling here is they said actually the carve out under 2A covers all types of measures and not just those that can be slotted into the domestic regulation heading, either under 2A or tied into Article 6. So basically, the interesting thing is the appellate body ruled that the reasons that Argentina gave for the measure were recognized as prudential, but the measures themselves, as applied, were not. So, do I have 3 minutes?
Yeah, sure.
Okay. So the interesting part for me is other issues that were not appealed. If we go back to the panel report, this is one of the measures affecting financial services, so the focus of why we're here. And I've highlighted the piece in the middle just to share with you what I consider to be the core of the measure. So the National Insurance Supervisor, with respect to reinsurance services, can authorize, at the request of an Argentine supplier, a foreign supplier can enter into a reinsurance contract and supply services from abroad through Mode 1. And this, as you see in the last word, is an exception to the rule. Here, we have the scope of the market access commitment here, only market access for risks exceeding $50 million can qualify for that intricate invitation-only market access provision that we just talked about. So in the panel report, undisputed finding, Argentina says, yes, we've made a full commitment under Mode 1. If we look at, by definition, GATS Article 28E, whenever you make a commitment, it covers all of the sector that's under commitment, not just a piece of it. And then here, the implications of a specific commitment are that you cannot limit the number of service suppliers or service operations. So Argentina explained to the panel that it had only made a partial Mode 1 commitment. And this kind of struck me because they have a full commitment and they cannot, therefore, limit to part of their schedule or condition on an invitation from an Argentine company or apply an economic needs test defined as 50 million floor. Now, I've heard some people try to explain that this is a domestic regulation and prudential, and therefore it's somehow excluded, and there are these maximum and minimum issues under GATS regulation. But my answer to all that is, if it's a maximum or minimum, it has to be non-discriminatory. And this is exactly discriminatory, so it doesn't qualify for any of those carve-outs. So this is the interesting finding. Footnote 584 is very, very interesting because in gambling, there was this zero quota decision, which some countries don't like, but it's there as appellate body jurisprudence. And this panel says they do not agree with the reasoning of the panel in gambling. Well, the appellate body upheld the panel in gambling very specifically on this issue. And we have appellate body jurisprudence that says when you don't follow established appellate body jurisprudence, this raises deep concerns. So I question that really kind of interesting and core finding of what it means to be classified under Article 16.2a or c when you talk about operations or services being supplied themselves. If you think back to that measure, we weren't talking about operations under 16.2c. We were talking about the ability of a service supplier to supply their services at all in that market for the part of the market that they wanted to cross-border, including under $50 million. So that's all I will share with you, and we'll move on to Joost.
Thank you so much, Daniel, for this tour de force. So there was a bit more than just the 42 pages in there, and I'm sure we might discover more. Joost, the unbearable lightness, and of course I should not fail to mention that this was in reaction, I believe, to an article or a staff paper written by Mireille, who's over there, the pioneer in all things likeness and services. And now we have likeness right here, not for the first time. My question when I read the report was if the panel wanted to go down this presumption approach and find likeness through exclusive origin, that was supposed to facilitate things, but it didn't seem to facilitate things. The word complexities, I think, appears at least 10 times in the appellate body report, always in relation to this. So I'm wondering whether the shortcut was a detour in this case, and we should actually approach likeness a lot more bottom up. But that's a bigger question that I have in mind. The other question that, of course, is looming behind all of this is this quote, always put in quotation marks, regulatory aspects, which is perhaps a bit too broad a term. But they are obviously there. They are part of the lifeblood of services in many sectors. And the question is, where would they appear? Likeness, less favorable treatment, or exceptions? I think we learn clearly not less favorable treatment, but perhaps before that in likeness, since we don't really have a ruling on likeness here, or only at the back end. And then what do we do with the panel ruling? I have no idea whether you intended to respond to that, but I'm throwing it out there for everyone to keep thinking, while there are a lot of other points that I know you will be making. Thank you very much.
Okay, thank you, Hannes, and good evening, everyone here in Geneva online. It's a pleasure to be here. I just had 3 points that I wanted to make, and I haven't been involved at all in this case, so I know people in the room here have worked on the case. I'm sure we get certain things wrong or simplify them, but it may be useful to have comments from someone looking at this from a distance. I'm very interested in this because I think the trade and tax angle is really the new frontier when it comes to WTO law, and I've been working with a colleague in Georgetown looking at the BEPS tax reform and what it means for the WTO. So 3 quick points, and I'll try to answer your questions doing so. First, why is this a really important case? Why should people pay attention? Secondly, I also find it a deeply puzzling, frustrating case. Who has won the case? What did the appellate body really say? And then a few broader takeaway points, questions that I have. Now, why is this an important case? I think having spent quite a bit of time talking to tax lawyers outside of the OECD, tax authorities, many of these people think that their field is separate and that trade, the WTO, has nothing to say about what they are doing. And until recently, we had many WTO cases on product taxes, indirect taxes. This is one of the first cases dealing with direct income, capital gains, corporate taxes. that the WTO deals with. There was the FSC case, but it was a subsidy case. I think this one shows squarely that tax people should pay attention to the WTO. Specifically, and I think that's really novel, they should pay attention, if anything, to the GATS agreement. Because one point I take away from this is that filing a GATS case is very easy. There's little standing trade flow requirements that the panel required. So Panama never had to show that there were actual trade flows being affected. This is big. You don't have to even show this really has an impact. Nor did Panama actually, sorry, Argentina didn't have to show that this had an impact, sorry. Nor did Argentina, sorry, no, I'm sorry, it's nor did Panama have to show that they were the one being favored or discriminated. So as you know, it gets complicated in this original panel report, but there was a violation found, not because the complainant Panama was discriminated, but because the complainant Panama was kind of favored. They were taken off the list, and the panel found this funny. Even though they were taken off the list, there was no exchange of information yet. So what I'm saying is GATS will find application very easily. No trade flows to be pointed at. You don't even have to show as a complainant that you were the one discriminated. What did strike me, though, on this first point is the panel paid very little attention or walked over the GATT claims very quickly.
And I didn't even talk about it.
Yeah, because I think some of these measures basically meant that if I'm in Argentina, I want to buy something from Panama, I'll be punished. I'll have to pay high taxes. It will be difficult. I think this, in many cases, will have an impact on trade in goods flows. But the panel said, well, this impact wasn't direct enough, so the product impact of an income tax measure wasn't sufficient for the panel, even though I think you could make the point that there was probably reason to apply GATT anyhow. Anyhow, my first point is tax people should pay attention. If the panel is right, perhaps less so to the GATT, but then at least to the GATS, because that one will be applied very, very rapidly. Second point, this is a frustrating case. Who won? It's kind of strange because Panama filed the case because Argentina put Panama on some blacklist. During the proceedings, Panama was taken off the list. So Panama won the case, right? I'm sure they're kind of happy. They were taken off the list. At the same time, before the panel, Argentina was found to be in violation, but as I said, because they favored Panama as against Hong Kong, who was still on the list. So Argentina got that violation overturned before the appellate body, so they were happy. It's one of these cases, and as an adjudicator, that's the ideal. You want both parties to be happy. I get the sense Panama is happy they were off the list, no big stir. What was it, a week after the Panama Papers was leaked in this appellate body report. So good thing for both parties, for the system. But what did the appellate body now tell us on is it okay to list countries, put countries on a blacklist if they don't cooperate on tax issues? We don't really know. My sense is that the service suppliers were probably but as Daniel explained, it's tricky, complex. The appellate body didn't want to complete the analysis. But what they clearly said was likeness there is a competition test, not a regulatory context test. So I guess good chances are that listed, non-listed service suppliers would be found to be which is kind of not surprising. Remember, Argentina affected service suppliers on an explicit origin-based basis. If you're in Argentina or if you're in Panama, that will determine whether you get hit or not by these defensive tax measures. So probably probably also discriminatory, less favorable treatment. again, because the appellate body made it clear that very much along the lines of its jurisprudence on the GATT, you cannot look at regulatory context. What matters is the impact on conditions of competition. Again, they didn't say so, but probably like and probably less favorable treatment. But they didn't say anything about whether tax transparency and not getting data from foreign tax authorities is a good reason to put companies on a blacklist. Probably they would have said yes to this, but the panel, remember, as Daniel was saying, the core finding of the panel was, if you ask me, that Argentina was discriminating because they basically took Panama off the list, even though Panama was not yet sharing the tax information, but they were only negotiating. And for the panel, that wasn't good enough. That was not justified. I'd be curious from our tax people online to hear whether this is something normal. Doesn't it provide an incentive to already take Panama off the list when they start negotiating? So for the panel, this was discrimination. So to me, that's puzzling. We know a lot now about likeness and less favorable treatment, and for us trade lawyers, it's fun to go into it. But for the tax people, I don't think we know much about this tax transparency angle and whether it justifies blacklisting, and what is it that what conditions can countries like Argentina put on other countries for being on or off the list. Last point, broader takeaway questions for services regulations in the future. As Hannah said, many years ago I wrote something basically arguing that likeness, both in GATT and GATS, shouldn't be the key factor. That we can actually afford to be relatively broad when it comes to defining likeness, comparables. But really the crucial element is, when do we have de facto discrimination, de facto less favorable treatment? What turns out is that I got it completely wrong. The appellate body always has the last word. Basically what the appellate body is saying, likeness is the core test. And we have to live with this now. Likeness is the core test, and it is a test only about competition. One question I have there is, as Hannes was saying, through that competition test, could we still bring in regulatory aspects? What the appellate body said was, and I think that's probably the most interesting element in the case, since we are talking here of services and service suppliers, likeness for services is complex. And we basically have to look at process and production methods, PPMs. We have to consider the supply and not just the service. Because remember, in the bananas case, a finding was made that basically, well, the three of us here, we all three provide legal services. We advise clients, we do some casework. Under the bananas jurisprudence, since we provide the same service, legal services, we are like service suppliers. Under the new test, the appellate body would look further than that. I mean, I'm an academic through a student law clinic, sometimes helping out with legal questions. That's very different from a big King and Spalding law firm, and yet again very different from
do we compete?
Exactly. So we need to ask questions beyond, do we supply the same service? I'm not saying it makes sense, doesn't make sense, but it's a big change from the bananas jurisprudence, and it may make it more difficult to show likeness, more complicated, more complex. My question is whether, a contrario, we are or should be deriving from this that for goods regulations, we cannot look at these supplier-producer elements. That's what the appellate body seems to say. So that's when I get worried a bit about drawing very strict lines between GATT and GATS regulations. Because if my reading is correct, it makes it more difficult to regulate goods than to regulate services. Because for services, it's more difficult for the complainant to show likeness, hence more difficult to attack regulations. That's my first point. So on likeness, to answer your question, I think difficult to bring in regulatory context other than through, and the appellate body said it, consumer preferences that may affect competition or service supplier characteristics. But again, I'm worried knowing how artificial the line can be between goods and services to take a radically strict approach to goods. PPMs cannot be looked at to determine likeness, or not as much as in services, and to take a more hands-off approach when it comes to services. Now the second point, and I'll end on this, turns this whole thing around, because once you do get over the difficult test of likeness under services, and I said it's complex, difficult, because you have to show not only do we provide a legal service that is like, but also our features as service suppliers have to be comparable. We need to compete, as you were saying. So once you get over that, less favorable treatment is almost a non-test. As soon as the regulation affects conditions of competition, you have a violation. So likeness is where the beef is, where it may be difficult. Less favorable treatment, it's almost a guillotine automatic approach of finding a violation once you've established likeness. And here is the crux for negotiators, for regulators. Be very careful when you make commitments. The preamble refers to all national policy objectives. The appellate body said explicitly, I'm sorry, but when it comes to services sectors where you've made a commitment not to discriminate, and you have a choice to make a commitment or not to make a commitment, once you discriminate between like services, like service suppliers, the only policy objectives you can justify your discrimination with are those in the explicitly provided exceptions in the GATS agreement or Prudential carve-out for financial services. So that means you have to be very careful when you make commitments, because when you make commitments and you violate them, there's a limited list of objectives you will be able to justify your measure with. I would say especially in the context of TISA, where you have negative lists, so you're committed to everything unless you specifically list your measure, you have to be really, really careful. Now, one safety valve is there that you may not have in the GATT, that is, if you've made a mistake, you can always renegotiate, the way the US arguably did it in the gambling case. But we all know renegotiation may not be as obvious as it looks like. So those are some of my questions, puzzles, and I'm not sure I'm reading this correctly, but a fascinating case, very complicated, one that tax lawyers should look into, but we don't really have clear answers yet on that tax-trade interface. Thank you.
Thank you very much, Joost, and thanks for those thoughts. I myself was troubled and intrigued by this whole notion of regulatory aspects leading to differences in providers, which could obviously be there, right? One provider comes from a jurisdiction where they have to keep records, another one comes from a jurisdiction where they don't have to keep records, so that, just to pick a random example, could indeed, if known by consumers, be a differentiation. But do the consumers have to know in order for me as a country to take measures that tackle that? I mean, that leads to a whole host of questions, among which one important one is the one that you highlighted first thing, which is the nexus between taxation and not only trade, but perhaps more specifically those people who do trade and thereby trade. So taxation, and in this case indirect taxation, has so non-product related, people related taxation, if you like, is of major importance. I want to flag one issue before I go to the tax story, precisely because it is a tax issue. And Jacques, sorry, I'm playing a bit pinball here. One question that is in the room is it okay to list countries ever? It is my impression that it is not entirely excluded, provided you have good reasons to do it. But it will have in many ways an impact. And of course, one area where listing countries could become at some point of relevance is, for example, in the vexed question of border carbon adjustment. And in many ways, that could also be a tax-related measure, and we would be back to precisely all those squares one that you have mentioned, and I think there were definitely several ones. So I'm intrigued by that, but I should not be too intrigued. I should hand over to Jacques, who will give us a perspective from Paris. That's always in itself a good idea, but more importantly, from the perspective of international, how should I say, international tax management, tax competition management. Jacques, give me the right terms. Thank you very much. You have the floor.
Yes, good afternoon. Good afternoon, everyone. I hope you can hear me. The interaction between trade and tax is a fascinating topic, and we've been told by previous speaker that tax people should pay attention. Well, we've been paying attention since the early 90s. That's when GATS was negotiated. I think if you look at the treatment of direct taxes, to refer to what some people have said previously, those are taxes on people, as opposed to taxes on products and services. And the distinction is quite important. GATT has a limited scope with respect to direct taxes. If you look at Article 3, it would be really direct tax measures that would be related to the increased sales of your products. For example, I would give you an income tax credit if you buy American cars or something like that. That is not the kind of disputes that we typically have involving tax and trade. If you look at what happened with GATS, GATS was initially negotiated without the tax people being in the room. So they put the traditional MFN and national treatment provisions in there, and then someone in US Treasury said, "You've created a disaster. Do you have any idea what you've done? All our bilateral tax treaties are now offside. All our distinctions between residents and non-residents are now offside, and that's the same in all the countries." So those of you who remember the negotiations, there were some very tense meetings, and I remember that at one, Les Samuels, who was then the assistant secretary in charge of tax policy in US Treasury, said, if you don't carve out taxes, there's not going to be a US signature on the GATT. And the outcome was a very unsatisfactory compromise that involves the subparagraph D and E of Article 17 on Article 14 on the exceptions, and very funny footnotes and paragraphs in the dispute resolution mechanism. So if you look at that, the main focus has been on national treatment, and the dispute between Panama and Argentina is on MFN. MFN, what the GATS has done is carve out differences resulting from tax treaties. There's about 3,000 of those bilateral treaties around. They are negotiated primarily to eliminate double taxation, but they do other things. They have non-discrimination rules. They have rules on exchange of information, which are very important, as the case between Panama and Argentina show. And these treaties obviously produce different results with respect to different countries because they're negotiated bilaterally. So the GATS people finally realized that they needed to carve out that. They should probably have carved out a little bit more than that. It was just not enough time to negotiate the proper treatment of taxes in GATS. If you look at the MFN exceptions of the US, you will see about 8 or 9, I don't remember exactly the number, exceptions with respect to most favored nation treatment that is strictly related to tax, things they do for tax, which differ from one country to the other. And there's one about reciprocal exemption for shipping income. There's one about countries that boycott a particular country in the Middle East. There's all sorts of these rules that are there because the US spent more time than others looking at problems that the application of the GATS MFN could create. And other countries at that time should have paid a little bit more attention when they drafted their exceptions. That gets me to the list of countries. List of countries exist in a number of countries for tax purposes. One of the first forms was with respect to CFC legislation, controlled foreign corporation legislation, for those of you familiar with taxation. And those lists were drafted for the purposes of saying, if you're a company, an affiliate resident of a country that is in our blacklist, then we will apply our CFC rules. We will end deferral of income. We will tax immediately the profits of the affiliate, even if they're not distributed. So that should have been in the mind of these countries when they drafted their MFN exceptions. And I'm not sure they did do that. Then if you look at what currently is around in terms of blacklist or list where you identify certain country for certain purposes, you only have to look at what the European Commission produced in June 2015, which is a compendium on the list of uncooperative jurisdictions that are found within the EU member states. So they look at all these lists that countries in Europe have. They look at whether countries have been identified in 10 or more of these lists, and then they listed that. So they did not do any other work than just looking at how many lists include your name. If you're more than 10, you're in the compendium of the list. So yes, that is raising issues. That is raising issues with gaps. Getting closer to what we've done with respect to the Global Forum on Transparency and Exchange of Information. You can see that this issue of blacklist has been around for a long time. We started the work on harmful tax practices in '98. One of the recommendations in the report that we produced in '98 was that we should list tax havens. And that obviously immediately in our mind created a GATS issue. Would a list be GATS compatible? Fortunately, we ended up not really producing a list, because when we were busy preparing it, we started talking to all the jurisdictions, and all the jurisdictions told us, as long as we don't have a level playing field, that all countries exchange information, you cannot list us and not list countries like Switzerland, Luxembourg, or Austria. And ultimately, all of that work sort of benefited from what happened after the audit of Mr. Orlenikoff in the US, which led to Bradley Birkenfeld spilling the beans on UBS, and then UBS asking the Swiss government that maybe bank secrecy was no longer a good idea, because otherwise they wouldn't be able to do business in the US. After that, our Global Forum on Transparency and Exchange of Information was able to tell countries, you now have to exchange information, notwithstanding any bank secrecy you may have in your own internal law. And if you don't do that, we'll put you on a list of uncooperative regimes. And fortunately for us, all the countries gradually accepted to do that. We then went one step further. We said, and just exchanging when the other country requests you is not terribly helpful if the other country doesn't know or does not suspect that there is a tax evasion. So we went into something else, which is automatic exchange of information. And we get closer to Panama and what has happened in May, when Panama finally agreed, probably as a consequence of the release of the Panama paper, to agree to commit to automatic exchange of information. That has happened in May, so very recently. I have to tell you that in April, because Panama had not yet committed to the automatic exchange of information, the G20, there is a communique from the meeting of the finance ministers, said that, and I quote, defensive measures will be considered by G20 members against non-cooperative jurisdiction if progress as assessed by the Global Forum is not made. So we were looking at the level of the G20 and OECD at possible defensive measures that would have depended on whether or not you would have appeared in the list of uncooperative jurisdictions. So you can see that this issue of blacklist has been around and is still around with respect to GATS. I'll conclude because I guess I don't have the whole day. GATS is unsatisfactory in the treatment of taxes. What is the right approach? Well, look at the Trans-Pacific Partnership. It's the approach that has been refined over the years after the negotiation of the GATS by the tax people. It's called the carve-out, carve-in. So you have a general provision that says, except as provided in this article, nothing in the agreement shall apply to taxation measures. And I'm quoting from Article 29.4. And then paragraph 3, nothing in the agreement shall affect the rights and obligation under a tax treaty. And then you have the carve-in part. Notwithstanding those exclusions, this is how taxes will be covered. And this is probably the right approach in terms of dealing with taxation measures. I have to say, before someone asked me the question, the 8 measures in the Panama-Argentina case were not all about tax. There were certainly 4 of them that were tax measures. They should have benefited from that kind of exclusion. Because again, as long as they are direct taxes is not like taxes on products and services. You cannot border tax adjust for a direct tax as easily as you can do for taxes on products and services. You cannot take into account the fact that the other state has a lower rate, for example. So how do you do that? Well, at least you ensure that the other state plays by the rules of the game in terms of having a transparent regime and a regime that allows you to access to the information. I imagine that some of that is controversial for some of you, but that is certainly the perspective from people who have been involved in the negotiation of the tax aspects of certain trade and investment agreements.
Thank you very much, Jacques. And I wasn't going to interrupt you because I was just too fascinated by that background, and certainly also by your suggestion of how to solve it. Being a thoroughly pro-WTO biased trade lawyer, I should say that as much as I'm fascinated by improvements overall in the international tax performance of everyone and cooperation and all that, the means to get there, which is essentially G20 pressure, is different from what I'd love to see in an ideal world, which is we move through principles, which is the WTO approach. But of course, what we see in this case, if I listen to you, is that you think it just doesn't fit and it shouldn't have been there in this way, except through a carve-in, as in TPP. I guess this raises the question: is the broader question, is the WTO in tune with international developments as they evolve? Border carbon adjustment was mentioned already 3 times today. Direct, indirect taxes, the difference, the proximity was mentioned. And of course, there is the whole perspective of the financial services industry, which is an industry that gets often mentioned when things go wrong, but is actually in many ways the grease that makes the whole machine, and I mean the whole machine, work in many ways. John, I suspect that you have some views on that, some of which you might want to share with us. I'm greatly looking forward to hearing your take on what you take, your take on this case, or what you want to take from this case away. John, you have the floor.
Well, Hannes, thank you very much indeed. I must say, after listening to all these experts, I really feel like a lion in a den of Daniels. As I try to formulate some views of my own, because of course I think it has to be said that outside the world of lawyers, except for the business sector or subsector that's intimately concerned, business doesn't usually take an intense interest in WTO dispute settlement cases, there's a tendency to leave it to the lawyers to extract the most important lessons and impart them to the wider community. So what can I say? I mean, it's not to say that we don't have an interest in cases. Far from it. We very much do, because the WTO is recognized as the source of hard law governing international dealings. And this is indeed why I'm getting a bit of echo, aren't I, on this? Will it help if I reduce the volume a bit? Does that make a difference? So we took an intense interest in the GATT Uruguay round and the strengthening of the dispute settlement system. And I think from a business point of view, we always knew, and this case exemplifies in a way, that in practice, it would not be easy to transfer the GATT principles that had been applied to goods to trade in services, because trade in services does differ from goods in various ways. And I think it differs, of course, in modes of supply and highly regulated services. And this is one of the things that I think is brought out in this case. The degree of regulation of the particular services supplier plays a role in how the supply of a service is looked at. It's part of the quality of the service that's on offer. I think also, and this case exemplifies this too, there's always been the question of how far and how the provisions of the WTO agreements could be made to square with the desire and in fact the duty of domestic regulators to take measures that were in the interests of consumers of financial services and the stability of the financial system as a whole. On the one hand, there is openness in trade. On the other, there is the need for regulation. Just as with the American the tax experts who were left out of the negotiation of the GATS, so in a way were the regulators. And just as there was a compromise in relation to tax, there was a solution in relation to financial regulation in the form of the Prudential carve-out. And ever since the Prudential carve-out has come into being, I think, we in business have always wondered what it would come to mean in practice. And this has been one of the great interests for me of this case, because there have, I think, been no decided cases which have brought much clarity on the ambit of the Prudential carve-out. And this is really the first case to look at. And so I looked at it in an interested way from that point of view. I've always wondered how the Prudential carve-out would, in fact, work in relation to disputes. There seem to me to be two areas where one has to look at this. One is the question of how far the dispute settlement panel would actually wish to question a decision taken by a domestic regulator. If it were a one-off decision, an episodic decision, as one might say, it seems to me that it would be very hard indeed for a panel to query that decision and second guess what a domestic regulator had decided to do. The question, I think, might be easier, and this is where this case is interesting, if there is not an episodic decision, but a course of conduct by a regulator of a particular kind, that is, the giving or withholding of some particular advantage in a whole class of cases. But it's this line of thinking that I think has led people to wonder how far the dispute settlement system would really be appropriate for disputes involving financial and regulatory questions. So this is a highly topical case, I think, for us. It's also highly topical because Argentina, in the measures it took, was aiming at bringing into being a set of measures that was central to its financial and economic reform, and they were measures that followed the precepts of recommended international standards. So I think it's been very interesting to see how that has been worked in practice. The question for me has really been in this: how far would the panel or the appellate body be ready to restrict the or even define the ambit of the prudential carve-out itself in any practical way? I've always felt that it would probably be rather reluctant to do so. And this case seems to me to show that that has indeed been the case. I've found, reading the papers on the case and also the third party submissions that were made, that while there are a good many statements on how the financial carve-out ought to operate in principle, there's been quite a reluctance to make any judgment on particular circumstances of the case or of the Argentine measures on how it should operate. And I read this as meaning that, much as one's expected, there is an ongoing reluctance to limit the prudential exception in any way, and therefore an ongoing wish that there should be some kind of gentleman's agreement that on the whole prudential issues are left to WTO members, and the dispute settlement process will not on the whole limit their prudential discretion. Now that's how I've understood the case, but of course I may be entirely wrong, and I'd really be very interested in what my colleagues feel about this kind of conclusion and the questions that arise in discussion on this point. There would be many other ways, of course, of looking at this case. There is the whole question of likeness, on which I'm frankly not an expert, and others have deployed a great deal of expertise. One point that also struck me as remarkable, but it may not be remarkable to those who are greater experts than me, is the apparent ease with which the appellate body comprehensively overturned a good number of initial panel conclusions and recommendations. One commentator described this as how to disappear a panel report. I don't know whether this is untypical in the extent to which it has overturned the initial panel conclusions, but it certainly seemed to me a feature that was rather remarkable. I think those are the only concluding impressions that I have to offer, which will just about, I think, bring to a conclusion over an hour of discussion between us, and so perhaps good to turn it over to those who can ask questions about it. Thank you very much.
Thank you so much, John. And certainly the prudential carve-out, when one reaches this stage, this point in teaching than one previously would have been well advised to say, well, probably it means everything under the sun, and in a way that seems to be what you're recommending, and that seems to perhaps also be what is required and needed, and that may be what the appellate body actually ruled. I do obviously, talking disputes is about talking by everyone in the room, but it's good practice to quickly see whether on the table there are some immediate reactions, to capture those, and then go and see what the many additional points are that will be raised from the floor. So Daniel, you have the floor, and we go quickly.
Thanks.
To
Just
a quick
two
reaction.
very quick points. First, in response to John, we have to look back and see, I think, where Panama was when this case was even initiated. And there were prudential reasons forwarded for putting them on this list and treating them differently. So only because the rules applied, and there was at least an implied threat of application of some rule to that prudential area, did we get their attention and get Panama off that list. So I think the kind of position that it should be left to members, yes, if they're operating in good faith and openness and transparency and not in a protectionist way, but as we see in some cases, you have to have some way to address those outliers. So I think that's just an observation. I don't know how you solve it, but that's just saying there. The other one comment quickly relates to the role of regulation and these other factors that come in, both in the context of likeness, where we say this greater complexity, and the panel and the appellate body over and over again, they say, yeah, it's very complicated, and we have to give them a role. However, we overrule you on that point. And then when we get to the regulatory aspects, where the panel went a little bit far in again looking at regulations, in order to see whether they could fix the measure by looking at the regulatory context. Is that a justification? Could the regulatory regime be the justification for that? And the appellate body said, no, it cannot be, and don't look at that. And you're overruled. And both of those kind of aspects of regulation show that a panel or the appellate body thinks, on the one hand, you shouldn't be looking at this, and on the other hand, there is some role for regulation, and we still haven't found. This case doesn't really illustrate the lines or lack of lines overlap between the market access and national treatment and the Article 6 things, but that will come. And that's a kind of precursor where you have to look at it, but don't look at it, and I'm going to overrule you, but who won. So that's another kind of issue to throw out there, not a resolution at all, but just to illustrate a tension in the case, I think.
Thank you so much, Daniel. One of the things that struck me was obviously we have legitimate regulatory distinction in TBT, and we don't have it in GATT, although a lot of people might have wanted to see it there, perhaps me included. And now we're told it's also not in GATS, and the panel's attempt to sneak it in without calling it that did not succeed, or was done in the wrong place. I don't know. Maybe it should have done and could have been done eventually in the likeness, as I said. But I guess the big picture, also after having listened to Jacques and John, isn't all well, in the sense that the bottom line of this case is, yes, no likeness, but we have no finding. Argentina wins in the sense that it's off the hook for this case, but maybe not in the next edition of the same case. But meanwhile, perhaps certain things get changed. I don't know. I can't predict that. But isn't the bottom line that somewhere in the process of analysis, everything that John and Jacques have asked for, meaning freedom for tax, reasonable tax, freedom for reasonable regulators, will be fine under the exceptions under the exceptions as in general and prudential carve-out. Sorry, Joost, I interjected again, and I don't want to prejudge what you want to say, but I wanted to just mention it.
Others, no,
Yes, you don't want to comment at this stage? Jacques and John, any immediate reactions, or would you also like to hear from the floor at this point.
I didn't mean to say that we wanted that I would want the Prudential carve-out to be as wide as possible, but it seems to me that it is likely to be fated to be so.
Jacques,
I just think it's the right time to go to the floor and get the questions.
Indeed. Thank you so much for this 1.5 rounds. This is the moment. We have one online question that I have seen, but before I raise that, I would like to open the floor. As I said, talking disputes is called talking disputes because you're supposed to talk here, not just let the dispute talk. So is there anyone who would like to raise her or his voice, raise a question or a comment? Both are welcome in this forum. Not immediately. I've got, of course, a number of questions, but I've already asked too many of them. So let me turn to a question we've received from Natalia Rodriguez. I hope I pronounced that all right. In tax treaties, there are also requirements of non-discrimination for individuals and corporations carrying on the same activities. Should the element of tax avoidance or other regulatory concerns be used for considering that taxpayers are not the same? And whether those concerns can be used for treating the taxpayers differently in the tax treaties? If so, should this cast light on the interpretation of likeness or application of likeness test in GATS, especially when services suppliers are at the same time taxpayers for those taxation-related measures? So the link between tax treaties and the treatment of discrimination there and the GATS, I guess in both practical and legal terms. Jacques, would you be interested in going first?
Yeah, sure. The non-discrimination provisions of tax treaties are somewhat limited if you compare them certainly to broad disciplines such as national treatment and MFN. We don't go as far as that. We do, however, have an equivalent of the like supplier when we say persons in the same or similar circumstances. So that's a functional equivalent. And it's been an issue which has not been decided by courts in the same way everywhere, because most of the tax disputes under tax treaties end up in domestic courts as opposed to international panels. And it's been an issue as to whether, for example, if, say, I will have a different treatment based on whether or not I can access information, or I have a different treatment because you are not giving me the information as to who are the beneficial owner of your shares, whether that would violate the non-discrimination rule. So it is an issue that we also face, this issue of like supplier in the tax terminology, same or similar circumstances.
Thank you so much. John, Daniel, Joost? No comments on that front. I'm looking around. You're all exhausted from this discussion. I'm not, I'm telling you. Yes, please go ahead, Joost.
No, I didn't want to speak before the questions, but I wanted to say one thing on your question of, is it all swell, no problems, the carve-outs are there. I think that's exactly what I was trying to warn the tax people for. So I'm very intrigued by, and it's a reality, so the tax people, when they see the GATS, they said we need a carve-out. And as Jacques was saying, it happened last minute. It's probably covering more than you would think. With the regulators as well, the solution is a carve-out. That reminds me a bit of the debates now on, okay, tobacco, let's carve it out. So, and I'm not sure whether carve-outs, in the true sense of, look, this is out and the WTO shouldn't say anything on this, is the right approach, nor is it what is happening here, because I think we probably haven't addressed the core element at least in the panel report. Remember, the panel report did find a violation. They did state that the Prudential carve-out didn't cover the listing practices of Argentina. That Article 14 didn't justify the way Argentina was classifying. So really, we have to look into this, and it seems that the WTO will have some kind of a check on how you blacklist. And that is really my question for Jacques and others. Did the panel get it right there? Is it unreasonable to say we will take you off the list as soon as we start negotiations? The panel basically said this doesn't make any rational sense because you take a country like Panama off the list even though it's not yet exchanging information. I'm not saying the panel got it right or wrong, but that is a fundamental statement on a tax practice by a trade panel, and that is something I would love to hear from you, whether this is objectionable, unreasonable, not seen, because that's, I think, the core role of the WTO. They get involved in all kinds of issues, from environmental to safety to health, financial services, and the way they do it is by just double-checking whether it meets some very basic non-discrimination reasonableness test. And here they intervened and they said, Argentina, you were not reasonable. And I'm really curious. So that is an intervention. This is your carve-out's not working. And I'd like to hear from you whether you think this is okay, whether they intervened too much, not enough. Because that's what the panel said. And as someone was saying, if this case gets refiled in some other guise, that's what they may say again. That's the crux to me, on the substantive tax issue that I really don't have an answer on.
Jacques, do you want to take that question?
Yeah. Yes, I think that's an excellent question. It's not really on the issue of the list. It's on the issue of on which factors have you developed your list. And that's where you see the attraction of a mechanism such as the one of the Global Forum on Transparency and Exchange of Information, where you have 134 countries that will peer review a particular jurisdictions, that will look at all its legal framework plus its effective implementation of the legal framework before deciding that this is a non-cooperative regime. So if a country were to base its measures on a list that would be prepared in that particular way, I think it would be in a lot better position as a country that would list a country 1 year and delist it the year and maybe relist it after 3 years because the personnel in charge of the list has changed or something like that. So obviously, without commenting on that particular case, I would think that the factors upon which you base your decision to list or not list are crucial.
Yeah, it was my. Thank you so much, Jacques. Just to add my 1.5 cents to this. When I took note of the panel report, I didn't read it properly at the time, but I first thought, well, the panel sort of has probably a good political sense because cases eventually get decided on discrimination late in the process, chapeau, unreasonableness. And true, the listing practice here was a bit like, used gasoline in all those cases where one had a feeling that it might not be all perfect or it could be improved. But when I hear Jacques, I hear, well, in this case, there were lots of good criteria out there, so one could probably solve it by just observing them religiously and then hope that it works. I'm sorry to come back to this point, but I am hearing border carbon adjustment right, left, and center here, because again, we're talking possibly about assessing countries by their overall performance and this and that, and whether or not they have a regime or not. And sorry, Joost, I'm looking at you because I know that you've been thinking about this. Do you think anything follows from this case for that, or are we in the same dark or light as we were before?
As I was trying to say earlier, to me, the appellate body seems to say that when it comes to services, features of the supplier can justify differential treatment because you have services and service suppliers. When it comes to GATT and products, they seem to say less so. And I'm not sure whether this is correct, the right way to go? Because we all know how difficult it can be to distinguish between a good and a service. So can you avoid scrutiny by implementing a service measure that is then easier to justify on PPMs? So I think there is definitely that angle.
I'd like to just comment quickly on something Jacques said. Jacques, you were focusing on the factors as the important part in looking through the justifications and the kind of peer, and I guess I would think that the process is as important, if not more important, than the factors. That if your process is you're one person sitting in Buenos Aires and you decide that you're going to be on or off a list based on great factors, then it's not as compelling as if you have peer review of 100 and something countries going around the world acting in good faith and reasonably in a process applying those kind of factors. So I think as we look at our other jurisprudence that we have, whether you're talking about maritime life and leaving it to one country to decide what standard they're going to apply and in which part of the ocean, you can be faulted on discrimination if you leave it up to that one country's context. But if you blow it out into a non-discriminatory, we're going to watch to make sure you apply the same factors in all places to all trading partners. That brings a different angle to the debate, which seems more kind of fair, and it's easier to comply with or it's easier to justify a measure based on those kind of bases.
If I could come in on that, I do see I quite agree that you can't, that it's understandable that the panel criticized Argentina for having moved a country from the non-cooperative to the cooperative list simply on the basis that they'd entered into negotiations without knowing what the conclusion of the negotiations would be. That can hardly be an objective factor, and is certainly not a prudential factor that goes to the heart of prudential regulation, which is the test of soundness of a supplier, soundness and safety of a supplier. The fact that a supplier has entered into negotiations is not a test of their soundness and safety. I think it seems to me that one can claim is objective. But at the other end of the scale, there is always going to be some element of judgment, isn't there, in prudential regulation? I mean, if we look at the question of fit and proper controllers and directors of financial services enterprises, the fit and proper test is often a test of whether a particular individual meets criteria of probity, competence, and financial standing in order to run a financial services supply operation. Now, one can try and lay out the criteria as objectively as one possibly can, but in the end, a judgment is involved, and if that judgment in turn enters into the nature of the supply and the supplier, I don't see how it can ever be put on entirely objective terms, on an entirely objective basis.
Thank you, John. That would underscore the emphasis on, on process that Daniel made, I guess. I'm sorry, Jacques. Yeah, the beauties and intricacies of video conferencing via web are that sometimes there is a delay. So I did not want to cut you off. Please, by all means, go ahead.
No, it's just to indicate that I certainly agree that the process would also be relevant. It wouldn't be the factors only, but of course the process really depends on the factors. If you decide on a factor such as there has to be effective exchange of information, that is somewhat more process intensive in terms of a factor, because you have to look at whether the instruments are in place and whether they're effectively used. If, however, you have a factor which is, if we have in place a bilateral instrument that allows the exchange of information and that overrides any domestic bank secrecy, I don't think you would need a very complex factor in a very complex process in order to determine whether the factor is correctly applied. That could certainly be done individually by each country.
Thank you very much, Jacques. There is also, there remains the fundamental question, where should it eventually be adjudicated, where things went right or wrong? And of course, as long as we have a trade problem, we have a covered agreement engaged. At that point, we have appellate body jurisprudence. And I'm certainly one who has never faulted for the appellate body or appellants for then engaging, because if members bring disputes, then the judge should not and cannot run away. Any other questions that come from you? I'm told there is one online, so I'll pull that up. Let me see what it says. Gabriel Gary says, with respect to the prudential carve-out test, the panel has a very differential test when it comes to define what is prudential. But when it comes to define whether the measure is made for prudential reasons, the panel looks into the design and application of the measure. What then should the panel consider when evaluating whether the measure was taken as a means of avoiding the member's commitment obligations? Daniel, please.
Well, I'll take a small crack at that, Gabrielle. So if you look at the third-party submissions, not everyone thinks there should be any standard at all. I mean, it should just be up to every member to decide what is for prudential and what is a prudential measure. So I think this question arises because of the debate that we had here. And I think what the panel tried to do, the appellate body reviewed in this context, is looking at Article 14 and then trying to extrapolate from that some ideas on how you would superimpose that onto a prudential carve-out that doesn't have the same kind of exceptions in it. And that's where we get the same kind of mishmash of law and reasoning that we have in other cases where we try and put things together that weren't meant to fit in Article 3 and TBT type stuff. But I guess the panel and the appellate body kind of both looked at this in a way to say there has to be some analysis. There has to be, we can't just leave this to the members, and maybe that's the issue for a next round, to see whether or not there should be any kind of filter, or whether this is total deference. I also thought in the same context it was interesting that they actually did a review, both in the context of 14 and the prudential carve-out, to see, and I know John will be watching this closely, as long as it's consistent with the members' other commitments kind of thing. Like, well, if it's consistent with the commitments, why do you need a carve-out kind of thing? So there are lots of dynamics going on there that I don't understand at all. I just think, in answer to the question, it was just superimposing a structure and thought process from Article 14 onto the prudential carve-out that doesn't fit well.
I have another question that is quite general in character, and I'm actually asking everyone in the room. The appellate body often quotes the panel in a way that seems to almost imply a tiny measure of critique, and one of those quotes is when it quotes a term, and one of them is when the panel said that services have some very special features, and that's some very special features, so all four words in a phrase. And it's true that perhaps the statement comes across as quite general, but I think what it articulates is that that what John mentioned earlier, which is that it is, that's a personal view of mine, it was absolutely unavoidable to bring services in, and there is a lot more to be done to bring services in properly into the world trading system. But whether or not we already have the tools ready by adapting GATT tools 20 years into the GATTs, to me still seems an open question, because it's very clear that there is a lot of specialty out there, and this, I will not divulge who it was, but a few years back I sat with somebody from the appellate body that was long before the case, there's no connection to a case, but he or she said, boy, Hannes, when legitimate regulatory distinction questions under the GATS came up, what will we do? And I can see a clear line being taken here for perhaps for the sake of clarity of jurisprudence. But I have to admit that I remain slightly troubled, because as much as I trust the exceptions to work, it is a tricky reliance, isn't it? Those were two questions in one. I'd be very keen to hear something from people in the room, or are you just blown away? Maybe we start with an easy question. Who won this case? Yeah, I would say it was very clear who won the appeal, but who won the case, I'm not entirely sure. Not sure. Please go ahead. If you could state your name and if you like affiliation, that always helps everyone.
Manuel T. Hankey. For Mr. Cosby, just the question when you said Argentina is obligated, right? It's a fully committed sector, reinsurance services. And did I understand correctly that the 50 million threshold, in your view, is not a valid type of classification?
Well, it's certainly a valid classification if you've taken on an economic needs test and scheduled that needs test. You can have also a domestic regulation that applies to all members in a non-discriminatory manner, but you can't take a schedule where you have none and a full commitment and then impose a monetary limit under which foreign suppliers cannot supply any service, whatever that service is. You can't do it in, big box warehousing. You can't do it in legal services. Somebody can't. Switzerland, for example, has a commitment in legal services, and they've specified not for Swiss law, but for international law, and they can do whatever they want and play with that definition. But then they can't tell me that I can't come here because I have the value of the transaction or law firm or it's above a certain limit. So that's all I'm saying. And I know that's there are others who would argue that you can slice minimum but not maximum, and they try and fit this into that box, but I don't think it fits.
If I may, with a follow-up. So basically, because from a domestic regulatory perspective, those types, wouldn't the Prudential carve-out come into play, or the so-called special nature of financial services? Because across many regulatory perspectives for financial type, it is a common feature to have a threshold, and this is a large threshold of 50 million.
Yeah, I mean, my comment referred to the positive commitment that the schedule says there's a commitment, and the panel didn't go through any of the exercise that you just mentioned. There was no mention of the prudential or justification or any kind of attempt to explain why it is. They just said it doesn't apply. I mean, there was no specific response to the challenge there. Maybe the complaint wasn't as precise on that issue, and I'm not saying that Panama intended to challenge that. I'm just saying it's striking to me as an observer, or if you're John sitting in London and you have Lloyd's there wanting to reinsure stuff and you see a full commitment, you have to at least get a justification, an explanation as to why this discrimination exists when it didn't exist before, and they introduce it now, and there should be a reasoning behind it.
John, would you like to comment on that? Minimum transaction value thresholds for insurance providers, or in this case, insurance providers?
Well, I very much agree with Daniel. I must say, I mean, I can envisage reasons why one would make a commitment on a topic like reinsurance and then introduce a prudential restriction. But I'd relate that more to the proven unsoundness of certain providers or something like that. In this case, one would really have to show that introducing a threshold like this was necessary, it seems to me, to prevent disruption of the domestic financial system, or words to that effect, within the meaning of the carve-out. And it's very difficult to understand why that should be if it's not explained. And that's correct. I haven't seen an explanation.
Thank you, John. I also feel that this would have been a case for a minimum turnover figure or that kind of thing, not necessarily a minimum transaction value figure.
Well, I think just from the, and I wasn't involved in this case at all, but just from a strategy perspective, if you're trying to get Argentina to do something, to change something, get you off a list even, we try to bring down the house. I mean, challenge the core measure that you, which means that Lloyd's and Swiss Re and the Germans and everybody else are going to come in and challenge all of that market, at least make the arguments to get more of an engagement on the negotiation than just letting that slide. That's kind of part of the issue as well. And then maybe they'll come back with some great prudential justification as well. But I guess it strikes me that if you allow participation over 50 million at any level, over 50 million, you are just reserving your market for domestic and not achieving a prudential purpose, because it's the higher value stuff is where you can find the disruptions, I suppose, if you don't have any objective criteria, as John said, that you apply to those service suppliers.
This leads me to a question that I'm always wondering about, and particularly again in this case. Manuel just said financial services are special. Yes, they handle a lot of money, so the service value is disproportionately small compared to the values they, shift from left to right and back. That's one reason why financial services need particularly prudence in regulation. But in many ways, my question remains, are financial services so different? And in that same vein, are the findings in this case valid for other services sectors, or have those on and off the podium had any feeling that might not always fit as well with every other service sector that is out there? And even if we take this very conservative view of W120, we are looking at 156, I believe, 58, one of those. And those are very broad sectors indeed still. If you think of all the services that you have ever touched, does this all fit, that what we've been discussing? It's a very open question, I know that. Anyone wants to relate to that? Daniel, Joost, did you feel that any of this could raise additional questions if applied to other service sectors?
I think the appellate body made it pretty clear that it will depend case by case, service by service, supplier. So it's very difficult to predict now. So I'm sure you can think of many differences between sectors. What I'm just afraid of is that we have this obsession of saying services is different, completely different, all of them, as opposed to goods. I think goods regulation today can also be very complicated. You have the supply chain. I don't think it's correct to say it's all about the product and to keep that direct, indirect taxes line constant, because consumers, regulators care about where the product comes from, what happened with it, who produced it. It can get as complicated as with a service. So for the appellate body to keep saying, services is complicated as a whole, completely different from all goods, I'm not sure. But not to say that between services sectors, probably you could find all kinds of differences. Which leads me to the first point you asked in the very beginning. Do you think there'll be more services cases now? And I'm not sure. One thing would tell me rationally, yes, because there's no standing requirements. You can just, as a services industry, convince Vanuatu to file all of your cases. If that's what you want, I mean, standing is not an issue anymore. Non-discrimination, likeness, it's all about competition, so it seems you can find a violation quickly. And the panels have looked into the carve-outs, including the Prudential one. So that seems to be an open invitation, file cases. On the other hand, I'm not sure. I'm not sure that countries looking at this case will feel comfortable filing one. Because what does it mean now? It's complicated. How do you show likeness? After years of litigation, basically no single finding coming out of the WTO. It doesn't look good. And states, I'm sure, are anxious or nervous about filing these cases because every state has regulations in place, and I don't expect more services cases. Although I think the WTO can handle them, but I'm not very optimistic.
I think that's right. I must say it's something that it's something that seems a key feature, that certainly for highly regulated services, the regulation is deep behind the border, and as just been said, every member of the WTO that has any regulatory structure, and most do, will be reluctant to question other states, other members' regulation. I think it will be, and this is where I get back to this question of a regulatory course of conduct versus a regulatory episodic decision. If there is a course of conduct that, say, a member has indicated that it will license a certain number of providers to operate in its country and then makes a practice of licensing absolutely none over years, it seems to me one can probably bring a case there. But if it's an episode of a decision that a particular provider will not be licensed, most countries would not wish to question the discretion of another country to take a decision of that kind, and would not wish to have their own discretion questioned, it seems to me. Goods is really different, because an at-the-border barrier on flows of merchandise raises on the whole different questions. The other thing about services, of course, is that where services require mode 3 in order to be delivered, there is, as they often do, there are the sunk costs of having made an investment in mode 3, and there's the natural reluctance of a service provider to get on bad terms with their host government. All these are factors, it seems.
I think this raises another connection. I would like to come back to that point that Joost just made, and Joost said that maybe goods and services are not all that different, and I could only wholeheartedly agree. 6-7 months back, we sat just at the backside of this in room S1. Rolf was there and a few others, and talked about servicification. And I think that's really the story that we are having going on. The processes that lead to final outcomes could involve at different stages goods and services, and goods again and services, and the idea to classify these as fundamentally different things is already quite absurd for businesses today. Most businesses wouldn't even think about making that distinction. A lot of economists often don't do it anymore because it doesn't make much sense in value chains. And the question is, could we, just by drawing that line called border, and say, well, when it crosses the border, that's when I look, and that's when I decide whether I'm in that regime or in something that is completely different. I think I would agree with that. And John brings in another aspect, which is the investment aspect that is most obvious in services, but again, obviously in goods is also just behind the corner, really. Daniel, sorry, I cut you off, but I was tempted.
No, please. I actually, further to Ambassador Tihanki's question, I wanted to revert back to Jost's observation that there was a whopper of a finding in this case of I am very sorry, but you've made a commitment, and you should have thought about that earlier, right? I mean, it's really very direct, and I wanted to ask Jost, why does that surprise you? I mean, you seem to be saying, oh, now we have to be careful that we have these commitments and there's less flexibility. I mean, is that surprising to you, the kind of strength of that kind of statement? I mean, I know some people tiptoe around it, but that seems to be a correct reading of a schedule. And I didn't know if you were feigning surprise or if that really surprised you, but it's definitely a very clear assertion.
No, my surprise is not that they found that there was a commitment. My surprise is that the panel said your way of classifying is not acceptable. That's what I think is the whopper finding in the panel, which I think, and I was happy to learn from the tax people around this table, does that make sense? It shows that the WTO will intervene at the margins, but it did, at least the panel. And that I find interesting. It means we can't take for granted that just anything will go under Prudential or under 14. But what I understand is that it actually made quite a bit of sense for the panel to say you can't take Panama off the list simply because you started negotiations. That's not good enough. And that I think is the core substantive finding that I take away. The appellate body didn't confirm it. But that's the important element of the panel report.
Anyone else who wants to come in here? The integration of goods and services? You're not tempted?
Rolf.
I can see the finger. Here we go. Rolf, you have the floor.
Yeah, I'm tempted. I'm Rolf Adlung. I was previously working in the Trade and Services division. I think there's one aspect also to be kept in mind, that the borderline, the definitional borderline between goods and services is extremely blurred. Contract manufacturing is a service in the classification list generally used, and contract manufacturing is distinguished from other manufacturing industries simply by the fact that the inputs are not used by the manufacturer. So the borderline is extremely blurred, and it could tactically be used or strategically be used by individual companies to be here, get in and out of services. And there's a second observation also. John has mentioned that he's a bit skeptical whether there will be many more disputes, in particular concerning Mode 3 under the GATS. But there are quite a number of disputes. These are the investment disputes under investor-state arbitration in investment treaties. And there have been, since 1995, since the entry into force of the GATS, more than 120 or 140 investor-state disputes in services, as compared to 7 or 8 GATS disputes. So there is something happening, but it's not happening in the WTO.
John, would you want to comment?
Well, that's interesting. I hadn't actually realized that the number of cases was as many, but of course it's not entirely surprising, I imagine, because for one thing, it avoids one WTO member having to have a dispute with another WTO member over what may be a regulatory issue, and on the other hand, for the business that brings the ISDS dispute, there is the prospect of a remedy in the form of direct financial compensation, which there would not be in a dispute settlement case.
Thank you, John. I actually wanted to come back to the hypothesis that you mooted earlier, which is that there might be a general reluctance for one country to go after the other when it comes to regulatory things. And I frankly have to disagree, or potentially hypothetically disagree. It might well be the case in financial services where there is universal agreement, and perhaps also extending to taxation, where the agreement is perhaps, hopefully, emerging that something has to be done and everyone is more or less interested in the same thing, although tax competition is still very much a feature of many governments' business case. But I'm wondering whether it's really true. I think if we look at goods and look at SPS and TBT and trade facilitation, frankly, I think we have a lot of thunder there that is happening, has always been happening, and is now bubbling up to filling also the docket of the panels of the appellate body. And I suspect, with or without a domestic regulation agreement, and I hope I see that before I die, we will see more of that, because I think there are regulatory points on which one can very patently disagree. Lots of very banal ones and a few sophisticated ones, and only when the crunch is really big and the prudential concerns are really major, then one notices that maybe the WTO is not made for war and peace; it's more for normal business. But I keep talking, and I should not be doing that. I'm supposed to chair this meeting. So let me again ask whether there are additional comments. Comments are welcome, or questions that are equally welcome. Yes, Kolo, most welcome. Go ahead.
Hi, as Hannah said, my name is Kolo, and I'm from ACWL. I have a question that relates to e-commerce. And I would like to direct the question to you, and to John. Do you still feel that in a world where we're probably going more into mode 1, would there still be that reluctance for governments to bring services cases then? Especially with regards to discriminatory regulation, of course.
No, I suppose it is true that there would not necessarily be reluctance in a case of that kind. When you're speaking of e-commerce, are you thinking in particular that a dispute might be brought about a failure to observe technological neutrality as between an e-commerce type of supply and a non-e-commerce type of supply? Is that the kind of case you had in mind?
Well, not so that technical. What I'm actually trying to convey is that the mode 3 way might not be sort of the future. And we're living in a world where, of course, service supplies don't have to be within the border. But, of course, they'll be affected by that regulation by virtue of their supply.
John? Do you want to
Yes, sorry, I'm trying to think out loud about this, really. And I suppose it is probably true that if one is looking at mode 1, I would still feel there are less likely to be disputes involving mode 3 than disputes involving mode 1. And if there are disputes involving mode 3, they are more likely, if they get that far, to go towards the ISDS investment dispute direction.
Indeed, an experience that often kicks in when one discusses services is it's extremely difficult to do this in the abstract, and one gets very easily lost in cyberspace in this case. But when one considers something straightforward as a German law that, prohibits foreign people, foreign lawyers, bad people such as Daniel and Joost, to provide services online when they deal with legal advice in German law, for example. So you have those things, and one can very quickly actually start imagining cases when one goes specific. Rolf's hint at contract manufacturing just shows how quickly one is there. Contract manufacturing will, in many ways, relate to both 1 or 2. So we're very quickly there. Let me ask for perhaps a last time whether there is additional remarks and questions, or indeed, as Daniel just mumbles, we should move on to. Yes, Manuel, you're most welcome. We still have a few minutes.
This one will be just simple for the lawyers to just guide the non-lawyers and non-experts. So, do we understand correctly that the appellate body has solidified the trend to make competition the main factor for likeness? And second, did the appellate body correct the panel as regards the non-following of the Antigua case?
Gambling.
I think the first statement is definitely correct, which goes back a bit to your question. How easy is it to file cases, mode 1? My sense is that if you make it a simple competition test, and if the measure affects the competitive opportunities of one group as opposed to the other, it may be quite easy to turn all kinds of regulation into a de facto discrimination. And the second thing on the gambling case, as I was saying from the very beginning, it seems that overall these cases, and I think it's a general trend of the appellate body, they push everything at the end of the road under non-discrimination. They've steered away from the GATT here, basically saying fiscal measures cannot be covered by Article 11 of GATT. And they also steered away from market access by saying, yeah, we disagree with the gambling panel, or we don't want to go as far as the gambling panel did. Which I think overall is a very intriguing point. The WTO seems to be, or dispute settlement, either about trade remedies or non-discrimination. That's what we do.
Just on the gambling case, I think there's still, first of all, the issue was not appealed. So the appellate body didn't clarify anything. So it's that this disagreement that a panel expresses that we don't like. I mean, they expressed it with respect to the panel, but it applies directly that they were so respectful that they didn't go directly after the appellate body. But it's pretty bold to drop such a footnote, I think. But in any case, it expresses a discomfort that panel had with indirect application of what would be called numerical limitations. And it has huge implications for e-commerce, it has huge implications for anything through Mode 1, but also Mode 3. I mean, anything. It's not resolved, and it will take another appellate body to come and remember that footnote and whack it down and say, please don't make such statements. We've already opined on that. Let's move on. But until that happens, that statement is still there.
Thank you so much. I think that implies a lot of fun for future panelists still to come. And of course, present and future appellate body members. I hope you will all join me in thanking our speakers today. But before I do that, I should make sure, and so I haven't thanked them yet, I should make sure that the most important housekeeping matter is not drowned out by your applause, which is that we will have a reception after this. The reception will be at the atrium, which of course is that beautiful open space that it gets very loud when it rains. I think it's not raining. I should also not forget again to say that as someone who works at WTO Advisors, I'm deeply grateful to our friends at ICTSD for being such a fantastic partner in organizing talking disputes. Again, thanks go to Finland for having made this possible, and thanks go to all of you for having been here. Special thanks goes to Manuel for pushing the envelope on certain points. And that brings me to thanks to the panel, Daniel, Joost, Jacques, and John. That's 3 J's and one.
They don't
one
even get
panel.
one.
And you had lots of Daniels and a Dan, so you were also more than
He's
one
the lion.
today. Thank you so much for making this possible. I think we have shown that financial services are complicated. The appellate body matters. Tax and prudence matters, and services will be with us within or outside the dispute settlement system. Thank you very much.
Thank you.